And good morning and welcome to Employment Hour in 30. John Scholes, Lior Samfiru from the Samfiru Tumarkin law firm. And I want to say, first of all, we're, a couple weeks now into January, Lior, and let this be the year that you start giving out the information and the viewers take in the information to be better equipped with employment law knowledge, their workplace rights, because this is the beginning of this month was the part-time wage increase, which is going to keep going for another year until it tops out. The fallout is going to be happening very shortly. We're going to talk a little bit about that later in the show. We'll get to the severance pay calculator. Phone number moving forward. We'll get to some calls today as well. 1-855-821-5900. And it is help@employmenthour.com. But we start every show and we will continue in 2018, of course, with the week that was. How are you?
Well, thanks, John. Happy New Year. And glad to be back here and to talk about employment law and workplace rights. And, you know, you're right. We have this forum here on TV to educate people and inform them and hopefully get them to understand that you have rights. If you're an employee in this province, you have employment law rights. The rights are quite good, they're extensive, and they protect you, but they can't help you if you don't know what they are. So we're here every single week. We're on the radio as well, you and I, to educate and inform both employees and employers, by the way, as to rights. So if you have questions about what you're owed, your situation, you give me a call. Let's talk about it, or pay attention to us over the next 30 minutes or so as we talk about employment law. To start us off, the week that was. Usually, John, when I talk about the week that was, which is a case that came across my desk, usually it's a happy ending type of a story. You know, here's the problem and here's how we resolved it. Well, unfortunately, this one doesn't actually have a happy ending. And let me break this down for you. I got contacted by a gentleman who was an IT manager for about 10 years. And he was let go because of some performance issues, and the company said, we don't have to pay you severance. It was nonsense. He clearly was owed severance. And when he called me, I told him, you were probably owed about 12 months' pay. And again, the company had paid him nothing. So he was obviously very happy, and it seemed like a very straightforward matter for me to help him resolve. Well, in speaking to him, I realized that he did the one thing, John, the one thing that I wouldn't want him to do. And you're smiling, you probably know what I'm about to say. He contacted the Ministry of Labor. Yep. He did. But he did more than contact the Ministry of Labor. He actually had filed a complaint with the Ministry of Labor a couple of months earlier before he called me. And the reason why you and I are now shaking our heads and we know why that's a bad thing is because by complaining to the Ministry of Labor, he's now given up almost all of his rights. So the most that he can recover from the Ministry of Labor is 8 weeks' pay in this situation. Remember, John, he was owed 12 months' pay. And now, because he filed that complaint, he can't withdraw it. He can't say, well, forget Ministry of Labor, I'm going to hire Lior to help me. He's stuck in that process. And I had to deliver those very bad news to him that now he's given up essentially on 10 months of income that he would otherwise be legally owed. So I wanted to bring this up here today because I want our viewers to understand that this is not something that you can do ever. If you lose your job, you're better off dealing with it yourself than going to the Ministry of Labor. Anything, frankly, is better than going to the Ministry of Labor because the Ministry of Labor can only enforce your minimum entitlements, which are a small portion of your full entitlements. And if you start that process, you're stuck in it, you can't get out, you give up your rights. The best thing, the easiest thing to do, just give me a call if you lost your job. Let's talk about what you're owed. Let's help you get what you're owed. The Ministry of Labor can't help.
You know, you say you're stuck in the process once you start, but you think it's now, you said it was a couple months when he filed until he contacted you. If you're a couple days in, or maybe you're watching the show this morning, it's like, well, I did that Friday. Do you have some leeway where you can go back and say, I take it back, you know, essentially?
Not only do you, it's actually very specific. You have 2 weeks.
Okay.
So you can withdraw your Ministry of Labor claim within 2 weeks, and then you're fine. If it's 2 weeks and a day or whatever, 2 weeks and 2 days, then you're out of time and you're stuck in that process. For this gentleman, it was a couple of months. So yes, if John is right, if you've filed a complaint with the Ministry of Labor and you've just done that, you may still be able to get out of it, but you cannot sit on it. You have to give me a call right away.
And once it is withdrawn, then we can go back to working with you and get the 12 months in this case. In this scenario.
So you're not stuck in that process and you can get your full entitlements. And the sad thing for this gentleman is it actually would not have been difficult to get him his 12 months pay. It could have been a couple of letters were done in a couple of weeks. But unfortunately, I can't help him. So I don't want anyone to ever have to be told that bad news again.
The email address anytime is help@employmenthour.com. The number is 1-855-821-5900. We get a ton of calls on the radio show every week. That goes for an hour. We've been doing that for about 4.5 years. This is our fifth year, I think. And we get to those calls. We have to play the good ones on the air to give you more information. So we'll get to one of those calls right now.
She works for a national company. Minutes in the day are kept track of diligently. Break times, lunch times, and she's allotted 30 minutes of personal time where she can go to the bathroom. Now, my wife, she has a bladder issue, and she has gone over on this allotted time. They suspended her for a week without pay because of this. She had offered to get a letter from her doctor stating this. She does not want to get suspended again because they said they will terminate her, and she has resorted to wearing adult diapers because she's so worried about losing her job because we're in our late 40s and we have kids to feed. She's not sure what she could do.
That doesn't sound right.
It's so wrong. I mean, I don't think I need to be an employment lawyer or an expert in the field to say that this is just wrong. It's wrong on a legal level, but it's also wrong on a human level. It's just absolutely wrong. So let's break this down and talk about it from a legal standpoint. First of all, an employer can't penalize you for taking bathroom breaks, okay? Forget about medical conditions for a second. They just can't. You're allowed to take bathroom breaks. They can't dock your pay for it, so that's very simple. It's right on the Employment Standards Act. But this is even more terrible what the employer is doing here, because this lady supposedly or apparently has a medical condition that requires her to visit the washroom more often. So what does the employer have to do? It has to accommodate. It can't say, well, now you're docked pay or now you're suspended. That's ridiculous. So the employer here has to accommodate. If that means allowing her more time than usual or giving her more flexibility with her shift, absolutely they have to do that. Otherwise, what this employer has done, it's a violation of the Human Rights Code. It's illegal. So what she should be doing is she should be immediately providing them with the doctor's note saying, I have this medical condition, here's the accommodation that I need. And if they do anything other than accommodate her, that's a human rights violation. That's a constructive dismissal. That's illegal. So for our viewers today, if your employer won't accommodate your medical condition, regardless what that medical condition is, it doesn't have to be like the one we just heard about. But if your employer won't accommodate, you need some help, some flexibility from your employer, and they don't provide that, that's wrong. That's illegal. You have to do something about it, and it starts with giving me a call.
1-855-821-5900 is that number to get a hold of Lior. Help at employmenthour.com. The reason we do this show basically is a lot of employment law myths are out there. People just have misinformation, gets them into trouble. They lose out on tens of thousands of dollars of severance, as you mentioned, and there's lots of wrong things going on in the workplace that people aren't aware of. So we put together a short list and busting employment law myths. I'll start reading these out. You can expand on each of these, and I know that when you're listening to these, some of these are going to sound familiar either with yourself or with family and friends. Number one, my employer can't terminate me unless I've done something wrong. Right. The only way I can be let go.
That is a big myth, John, and I get calls like that every day. I get emails like that several times a day saying, I didn't do anything wrong, I was let go. That is wrong, or that's a wrongful dismissal. Well, not necessarily. It's not the case. That is a myth. The reality is, John, that an employer can let an employee go at any time and pretty much for any reason, as long as proper compensation, proper severance is paid. So you may not have done anything wrong. You may have done everything right. Maybe you have the better performance reviews than those of your colleagues. Your employer can still choose to let you go, but severance has to be paid. Now, when it comes to severance, that's where the issues arise, because so many people believe that severance is a week per year or 2 weeks, and that's wrong. It's based on age, position, length of employment. We'll talk about that a bit more later. And a lot of employees get wrongfully dismissed when they get less severance than what they're owed. Now, the exception to the rule that the employer can let you go for any reason is you cannot be let go for a discriminatory reason. So you cannot be let go because of your age or race or ethnicity or disability, regardless of severance, irrespective of how much severance you get. But if it's not a discriminatory reason, your employer legally is allowed to be unreasonable and let you go, but severance has to be paid.
It may be, morally frowned upon or ethically,
sure,
but they can legally do it. We often joke that, if you go in one day and your boss says, you know what, you drive a blue car, I prefer red cars, I'm letting you go. Completely bizarre situation.
Bizarre, ridiculous, probably not going to happen, but could happen legally. Your employer can be unreasonable as long as they're not being discriminatory. Again, ethically, even from a business standpoint, an employer maybe should not do that, but from a legal standpoint, yes, you can be let go, but severance has to be paid.
Part of the show this morning, we are busting employment law myths. Number two, I cannot be let go if I'm on leave. Cannot be terminated on leave.
And a lot of employees do get let go if they're on a leave. Usually it's a medical leave. And the rule is this. The rule is not that the employer can't let you go if you're on leave. The rule is that your employer cannot let you go because you're on leave. So if you're on a medical leave, your employer can't say, well, I don't like that you're on a leave. It's disrupting my business, so I'm letting you go because of it. That's illegal. That's a human rights violation. It's a big no-no. An employer cannot do that. But if you're caught up in, let's say, in a bigger restructuring, and you lose your job as part of that restructuring, the fact that you're on a leave does not change the fact that you can be let go. So you can be let go on a leave. One thing I want to mention, though, is if you're let go while you're on a leave, assuming it's a medical leave, you actually may be owed enhanced severance, more severance, because presumably if you're sick, it's going to take you longer to find another job than if you were healthy, which means the severance that you're owed is going to be more as well.
Another employment law myth, rather, we want to bust here this morning is because I'm a federally regulated job, we've had phone calls on this as well, I can only get a few weeks' pay. As far as severance is concerned, not right.
So most employees here in Ontario are regulated provincially, but there are some employees that are regulated federally. For example, if you work for a bank or a railway company, aviation, those are industries are regulated federally. And a lot of people believe the different severance rules apply if you are regulated federally, that you only get a week or 2 weeks pay. And that is wrong. That is a huge myth that I completely want to bust right now. If you're working for a federally regulated employer or a provincially regulated employer, the amount of severance, your full entitlements are the same. They're not less, they're not more, they're exactly the same. So whether you work for an aviation company or you work at a grocery store, again, the factors are age, position, length of employment, not whether you're working for a federally regulated employer or provincially regulated employer. So you get the same amount of severance and don't accept anything less than that.
Help@employmenthour.com is the email, 1-855-821-5900. Anytime to get a hold of Lior and a member of his wonderful team at the firm. We are talking about busting employment law myths this morning here in the show. Number 4 is this: my employer has the right to change my job duties, my pay structure, location of my job, all of those things. They can do it.
A lot of people believe that, John. Well, if I'm working for the company, if I'm working for the employer gets to set the rules. They get to say, well, I'm going to pay you this much instead of that much, or I'm going to demote you to this role, or I'm going to move you over there. No, an employer can't do that. It's not something the employer is allowed to do. If you have a job and the job says you make $60,000 and you work as a marketing manager and you work in the Ottawa office, well, the employer can't change those terms. They can't relocate you, pay you less, demote you. You have a right to the terms that you've agreed on. Now, what happens if, in fact, the employer decides, despite what I said, to make those changes? Well, you have the right, potentially at that point, to treat your employment as being terminated, what we call a constructive dismissal. And that means you can leave with your full severance. The problem with accepting a change, you know that, we've spoken about this before, is you accept the change, you give the company the right to do it again in the future. You've opened that door and you may have problems down the road. So if your employer changes the terms of employment, stop, understand that it's illegal, they can't do that, and you have rights at that point. The employer doesn't get to call the shots when it comes to changing the terms of your employment.
The last myth, save the big one, the best one for the end. It's like opening that final Christmas gift. The Ministry of Labor can help me get my full severance. Stop right there.
Well, except Christmas gifts usually are a good thing, positive things.
Yeah.
So that is a huge myth, John, and we started the show by talking about that, is a lot of people believe, well, I have a problem, I'll go to the Labor Board. I'll go to the Ministry of Labor. They'll help me get what I'm owed. And in some situations, that is actually accurate. If you're owed overtime, they can help you. If you're owed vacation pay, yeah, no problem. But not when it comes to termination of employment. The Ministry of Labor cannot help an employee get their full entitlements, not even a majority of those entitlements, only a small fraction. So you cannot, should not, under any circumstances, go to the Ministry of Labor when you lost your job. Other situations, yes. If you lost your job, you get legal advice. You don't like me? Fine, go to another lawyer. But you have to speak with an employment lawyer when you lost your job, full stop. If you do anything else, you're losing potentially tens of thousands of dollars that you're legally owed.
The number is 1-855-821-5900. Email is help@employmenthour.com. We'll take a short break. When we come back, we're going to get to the severance pay calculator. In the meantime, you'll want to check it out. You can go online to severancepaycalculator.com. That and more of your phone calls coming right up. Employment Hour in 30 here on Global.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
The number 1-855-821-5900. Email as well, help@employmenthour.com. The reason why we're standing here is because we like to get into this segment every show, a very important tool, which you crafted, put together about 4 years ago, almost 5 now, Lior. That is the Severance Pay Calculator. You can have that at severancepaycalculator.com. Describe what it is first.
Well, John, I wanted people to have access to information. That's why we do the show. That's why we're on the radio. It's all about access to legal information. But one of the most important pieces of information that someone should have is how much severance am I actually owed if I lost my job? What is the number? Am I owed 6 months pay, 2 months pay? Is it $50,000? Is it $200? So I wanted to make that easy. I wanted to make it as easy as possible for people to get that information. So I created the Severance Calculator. It's available at severancepaycalculator.com. And once you go on the website, you answer 3 simple questions, anonymous. You don't have to put your name. You don't have to put the name of your employer. You simply answer how long you've worked, the type of job that you have, and your age. And you're done. It's going to tell you whether you're owed 2 months pay, 6 months pay, 12 months pay, anything else or more or less. It's such an important tool to have because if you're walking out of a termination meeting, you're holding your severance papers in hand, how do you know if it's adequate? Well, first of all, I'll tell you in most cases it's not adequate. In most cases it's pennies on the dollar. Well, now you can go to severancepaycalculator.com and find out exactly what you are owed. And you know what? Maybe you haven't lost your job. Maybe you're just worried about it. Or maybe you're curious. And if you think you know, you think you have an idea how much severance you're owed, still go to severancepaycalculator.com, find out the real number. I bet you anything you'll be surprised.
Why don't you run us through an example quickly?
So, John, let me use an example from someone that contacted me recently in my office. So this person had worked for the company for 10 years.
Yep.
And he was 43 years old. He was making $64,000 as a nurse. Well, what happened there when he was let go, he was offered 10 weeks pay, John. Well, guess what? 10 weeks pay? Nonsense. The severance calculator told him the real amount, which was 12 to 14 months pay.
That's a massive difference.
The difference, John, between 10 weeks and 12 to 14 months pay. I mean, in real numbers, that's over $50,000 that this person was owed. And there's nothing unique about this. I'm not giving you this example because, oh my God, this is such a crazy, strange example. This situation happens every day. This is one example. I could have picked 100 from this 1 week alone that I get from people using the calculator. So don't let that happen to you if you lose your job. Just like this person did, they found out that they're owed over 12 months pay instead of 12 weeks. I'm helping them get that number. We should be able to get that resolved in a couple of weeks. Don't accept pennies on the dollars. That's ridiculous.
And a lot of people, you know, they go to severancepaycalculator.com, they use the app, they come up there and they go, whoa, 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 this number is so much higher than what my severance offer is. They think there's a bug in the system, but there's not.
Well, I understand that. If you're offered 10 weeks, you use the calculator and it says 14 months, you may think, wait a second, does it really mean 14 weeks and the difference is only 4 weeks? No, it's not. There's no bug in the system. If it says months, it's months. The reason why there's such a discrepancy is because most people are offered a lot less than they're owed. An employer often counts on the fact that an employee may not realize how much they're actually owed. So you now know, if you're listening to us, you'll never be taken advantage of in this situation. You'll always know because you can always go to severancepaycalculator.com.
The phone number as well, 1-855-821-5900. You want to get a hold of Lior. We take calls all the time on our weekly radio show, have for years, so we'll get to another call now. Should be interesting. Have a listen to this.
My company is looking to relocate us to one of 2 locations, one being about 70 kilometers away and the other being about 45 kilometers away. And basically they're telling us there's not too much we can do, that we have no choice. Right now I'm 2 kilometers from work. Like, I've been with the company for 20 years now, purposely moved closer 15 years ago just to be closer, and now they want to relocate us.
We talked about this.
We talked about this, and this is a very common situation that I get. A company relocating an employee significantly. So the company apparently told him that he has no choice. Well, I beg to differ. Of course there's a choice, and the choice is very simple. you don't have to accept it. And if they still end up doing the relocation, that is a constructive dismissal. You can treat your employment as being terminated. When you're going to have to commute that much longer to work now, that's a big deal. That's a significant change. And if this person has worked there for all these years, he could be owed 18 months' pay, which is enough time that he'll get to find another job. So you don't have to ever feel that, well, now I have to commute an extra hour each way because my company's moved. You can do that if you want. That's your choice. But the other option that you have is to treat employment as being terminated, constructively terminated, get your full severance and move on to a different job. And that's exactly what I told this person.
An hour away is a great distance. What would be reasonable? Across the street, couple K across town?
You know, it is an individual type of an analysis, because if you have a car and you drive, it's maybe different than if you're someone that's an older person who's relying on TTC exclusively or other public transportation. So, you know, for you to drive an extra 10 minutes may not be a big deal, but if you had to take public transportation,
3 more buses, right?
It could be 3 more buses in an hour and a half. So it's an individual assessment. What may be a big deal for someone may not be a big deal for you, and vice versa. So if you are facing with a situation where the employer has relocated, give me a call. Let's talk about your specific situation and find out how this is going to impact you and whether you have the option to treat this as a constructive dismissal.
Help at employmenthour.com, and the number Lior keeps mentioning, 1-855-821-5900. Take a short break. We'll get back to your phone calls right after that. Employment Hour in 30 here on Global.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. 1-855-821-5900 is the number you want to keep on you. Slide it in your wallet, keep it on your phone, get a hold of Lior and his firm anytime. We take a ton of phone calls weekly on the radio show, which we'll be doing for, I guess this will be the 5th year. Coming in 2018, so looking forward to more of those. And this show as well, we like to play the interesting calls, give you a little perspective on what we talk about each week. We'll get to another one right now.
A year and a half ago, I was laid off from a position that I had been at for 2 years, manufacturing. They just called me in and said, okay, we're laying you off, with no intention of calling me back. I asked, am I getting called back? And they're like, no. Now, there was no severance paid or anything. They just said, here you go. Here's your record of employment and all that, and I was set on my way. I am 38 now.
Yeah, wow. John, I mean, it's very simple. You know, it's very simple. I'm going to give you a rule now that everyone should remember. And if you keep this rule in mind, you'll never go wrong. You cannot be let go or laid off without severance. Full stop. Unless, of course, you did something awful. But in most cases, if the company, for its reasons, decides to lay you off, let you go, terminate, whatever you want to call it, fired, you are owed severance. So for this particular person, whether it was a temporary layoff that the company had in mind, whether it was a permanent layoff, he says after a couple of years working, he didn't get any severance. Nonsense. It doesn't work. It can't be. It's illegal. He is owed severance. And so are you if you lost your job. A lot of companies may think, well, let's call it a temporary layoff. And if it's a temporary layoff, we don't have to pay you anything. In most cases, a temporary layoff is a termination, which means you're owed the same severance as if it was a regular termination. So don't let that happen to you. You're owed severance. And this particular person, I did speak to him off air when he had initially contacted us through a radio show. I got him the severance that he's owed. It's simple. It's easy to do. And don't let anything else get in the way of you understanding this simple rule.
Help is easy for you to get as well. Simply go to help@employmenthour.com or 1-855-821-5900. We get a lot of emails every week, and you get hundreds every day. All kinds of matters as far as employment is concerned, and I'll read one anonymously, of course. So this is an email we got over the past week. It says, I was laid off, Lior, with 2 weeks lieu payment right after returning from a 35-week parental leave. No notification or warning. Am I entitled to severance package? I know the Employment Standards Act states that any employer can dismiss an employee with 2 weeks lieu payment, but this doesn't seem right.
No, wow, it's not right. And there's a lot to break down here. Right. So let's start with the fact that if this person is let go after coming back from a parental leave, my first question is, why are you being laid off? Why are you being let go? Because if you're let go, even remotely in part because you took a parental leave, that's illegal. That's a violation of the Human Rights Code. It's a violation of the Employment Standards Act. It's absolutely illegal. Forget about severance for a second. They can't do that. So that's my first concern here, is why you're being let go after 35 weeks of parental leave. So that aside, let's assume for argument's sake, for the purpose of this analysis, that the termination is otherwise legal, that it wasn't because of the parental leave, it was unrelated. If it is, then it is a question of severance. And this particular email, the person that contacted us said, well, the Employment Standards Act talks about 2 weeks pay. Well, let's forget about the Employment Standards Act. The Employment Standards Act only outlines certain minimums that you're owed. Those minimums are a small fraction of what you're actually owed. So I don't care about that for the purposes of this discussion. Your full entitlements under what we call the common law are based on your age, your position, and the length of your employment. Okay, so you're potentially going to be owed 5, 10 times even more than what those minimum entitlements are. So no, it's not 2 weeks pay that this person is owed. So not only is there potential human rights issues here, because the person was let go after coming back from a parental leave, they're owed much more severance as well. So it's a wrongful dismissal, potentially a human rights violation. So if you're let go, you come back from a parental leave, from a maternity leave, stop right there. Let's immediately analyze why you're being let go, because the termination itself may be illegal. Your company can't let you go, penalize you in any way because you took a parental leave, even if you took the full amount and they didn't want you to. Too bad. The law says you can do that. You can't be penalized. And of course, if the termination is otherwise legal, we still have to make sure that you get the severance that you're owed, because most people don't. You know, there's another avenue if you want to ask questions and have them anonymously read on the air, get your questions answered during the show. That is terminationquestions.com. Very simple. One here for you, Lior. I'll read this to you. You can deal with it. After 6 years on the job, I took an extended unpaid leave. My doctor ended up disclosing my illness to my employer, who didn't want to accommodate my condition. We talk about accommodation all the time. They became frustrated because I hadn't returned to work. Then they fired me. What do I do? Yeah, well, John, I still don't understand why employers don't get this. No. I really don't. If you're an employee and you're providing a doctor's note says you can't work, that's it. The analysis ends right there. Your doctor is judge and jury when it comes to your ability to work. The company can't say, we don't believe your doctor, or we don't agree, or we think there's something else. If the doctor says you can't work, full stop. And what can the company do? Well, the company can ask questions about, well, how long are you going to be unable to work? Is there something that we can do to accommodate you? What they can't do is disagree. What they can't do is penalize you if you're following your doctor's orders. They can't do that under any circumstances. So in this particular situation, the person is allowed and should be allowed to take as long as they want to. And if the company prevents that, penalizes them, lets them go, threatens them, does anything, they need to call me and I'll be able to help them. You've often mentioned, I know as we close here in a couple of minutes, the difference between them being able to ask prognosis versus diagnosis. One they can't do. One they can't do, and that is diagnosis. Right. So what can the company not ask if you're on a medical leave? Well, they cannot ask what is the medical condition. They cannot ask what medication you're taking. They cannot ask what treatment you're getting. Those are personal things. They're private things. Wow. The company cannot ask those questions, but the company can ask for your prognosis. In other words, how long are you going to be off work? What limitations do you have? How long do we expect those limitations to last? When are you going to get another opinion, or when are you going to be seeing the doctor again for an update? Those are questions that are legitimate. If your company does ask you questions that go beyond that, they want to know the specifics of your medical condition, they're not allowed to. And you can say no, and you can be protected and be confident that you can't be penalized for saying no by refusing to provide personal, private medical information.
Kicking off 2018 in a strong way, my friend. Continue lots more of this to go as the show continues. If you want to contact Lior between shows anytime right now, as a matter of fact, the number 1-855-821-5900. It is quite simply help@employmenthour.com, and we talked about it a short time ago, something you should always try, use on your tablet, your phone, your desktop. That is severancepaycalculator.com. Find exactly how much your severance offer should be, because we can guarantee you that piece of paper in front of you with that number is way off the mark, so you don't want to trust that. So again, till next time, Employment Hour in 30, right here on Global.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.